Good morning, everyone. My name is Bob Fuerst. I am a partner at Meyers, Friedberg, and Lewis. I want to welcome you all to our last breakfast briefing of the year on some alternative methods for selling commercial real estate. We're going to start, my partner Ron Friedberg is going to start off talking about receivership sales and particularly focusing on the new Ohio receivership statute. Then Mark Abood from Hanna Commercial is going to talk about auction sales, and I'm going to finish off talking about note sales and sealed bid sales. We're going to try to save some time for questions at the end, but feel free if you have questions during our presentations to ask them. So with that, I'm going to turn it over to Ron.
Thank you for coming, everybody. I was at a mediation in Columbus all day yesterday, which was kind of a mess, but that's another story. And as I'm driving back, Bob emails me and says, well, our managing partner, Peter Turner, who usually does these introductions, isn't able to attend today. So do you want to do the introductions or should I? And I thought about it and I said, you know, age before beauty, and I'm speaking first, so I'll let Bob take the honors. But I do thank everybody for coming out this morning. It looks like winter is finally here. I'm going to talk about Ohio's new receivership statute. When we originally thought about doing this presentation last summer, when the three of us first talked about this receivership statute was really new. But it's still pretty new. It's been in effect about 8 months. And there's a number of changes, and the most prominent changes to the receivership statute are to assist in the expeditious, orderly sale of real property free and clear of liens. The history of the law, which actually different real property groups and some bankruptcy lawyers and talked about doing these amendments back in 2012. And finally, what was House Bill 9 was signed into law by Governor Kasich on December 19th, 2014. And the new law became effective on March 23rd of 2015. And what the law does, it doesn't so much change Ohio law, but it provides some clarity and uniformity. A lot of what the statute entails was set forth in case law, but because case law can vary from county to county, there was still some hesitancy and some lack of confidence that this was a uniform law and procedures for selling property and the other things that this new statute tries to provide some certainty and clarity and uniformity. What the law primarily does, and there's some minor changes that we're really not going to get into here, but what the law primarily does is it modifies the way receivers can be appointed. It's actually easier to appoint a receiver in Ohio now than it used to be before this statute. And it adds to and clarifies the powers of receivers, including, most importantly, the power to sell real property free and clear of liens. The Ohio receivership statute is codified at Revised Code Section 2735, and I'm just going to go over some of the changes to various sections of that, and then we're going to focus mainly on the changes to 2735.04, which talks about the powers of receivers and also talks about the enhanced ability to sell real property free and clear of liens. 2735.01 is what prescribes when a receiver can be appointed. And if you look at the red here, that's the new language. It used to be, if you're talking about a borrower, a lender, a mortgagee, who wanted to appoint a receiver in the event of a default, you had to show default, and you also had to show that the property is probably insufficient to discharge the debt. If you look at some of the old case law or pre-statute case law, it talks about how receiverships are extraordinary circumstances, and it was more of a case of last resort instead of a case of first resort. That's not the case anymore. if you have in your loan documents the consent of the borrower to the appointment of a receiver in the event of default, that's ball game now. It used to be that even if you had that language in the document, the court would still go through to see if these extraordinary circumstances exist, but not anymore. If you have default and you have a writing which authorizes the lender to put a receiver in place, there's going to be a receiver. Another new provision of the statute is that a receiver may be appointed by a court if there is to enforce a contractual assignment of rents and leases. That's new. So for income-producing property, if there's a default on a mortgage and the lender wants to put a third party in place to make sure that the income that's thrown off of that property goes down to pay the debt instead of being put in the owner's pocket or going elsewhere, you could get a receiver appointed automatically in those circumstances. That did not used to be the case. There's some changes to 273502, which talks about who is appointed as receiver. Now, this first bullet point is interesting. It says, in selecting a receiver, priority consideration shall be afforded to any of the qualified persons nominated by the party seeking the receivership. The statute's so new, so I don't know what priority consideration means, whether if the lender wants a specific person to be a receiver or a specific entity, that receiver will be appointed, because it's just too new. I could tell you how it used to be. It used to be a coronation by whatever judge had the case of who contributed most heavily to his or her political campaign. There was a lot of patronage involved. And we'll have to see how this priority consideration plays out. But at least, and it does say no nomination is binding upon the court, but at least there is some language in the statute that says the court should give priority consideration to who the lender wants to nominate as the receiver. The only thing the statute says about who can't be a receiver is a party can't be a receiver. Attorney for the party can't be a receiver unless the owner and all the parties with an interest in the property consent. Another thing, another limitation on the appointment of a receiver, that if you are appointed, or if there is an application to appoint a receiver of an entity, a corporation, a partnership, limited liability company, or any other entity that's created under Ohio law, the receiver has to be a resident of this state. So there's a little bit of patronage there. I was involved in a case where a lender, is actually a special servicer, wanted to appoint an out-of-state receiver for a well-known property that went into receivership in Northeast Ohio. The receiver was out of Chicago. The court did not appoint the receiver out of Chicago, appointed someone locally. And I was kind of bummed out about that because I think I had an in with the receiver in Chicago to be appointed as receiver's counsel. But you know, it does say that when the receivership is appointed for an entity, that the receiver has to be a resident of the state as well. Now we're going to get into the main changes that we're going to talk about, which is the sale of property free and clear of liens. The receivership, all of this red is new provisions to the statute. So all of these sections didn't exist before March 23rd of 2015. The new statute says that a receiver may sell property free and clear of liens by a variety of means. You could have a written purchase and sale agreement that you've actually negotiated and signed, and you could submit it to the court and say, we want to do this deal. I've been involved in those. I know some people that are here have been involved in those where there is a pending deal, and we just want court approval of that. And rather than go through a foreclosure process to clear title, we just want the court to bless the transaction and transfer the liens on the property to the sale proceeds. It doesn't have to be a pre-negotiated written contract, though. You can have a private auction, and Mark's going to talk about private auctions. You could have a public auction similar to a foreclosure sale, but a more, not through the sheriff's office and not with some of the limitations and procedural mechanisms you have to go through what is an arduous foreclosure process. or any other method that the court determines is fair and reasonable under the circumstances, so long as there's a belief that the return to the receivership estate is maximized. The new provisions also say that the court doesn't have to require a valuation, and if it does require a valuation, it doesn't have to be an MIA appraisal. When you go through the foreclosure process, there's usually 3 appraisers appointed, and it takes a long time. You also have that 2/3 minimum bid requirement in the foreclosure process. You could have a broker's opinion of value. You could have any valuation, and it says by any evidence that the court determines is appropriate. And it also says that in a public or private auction, and again, Mark will talk about those, you may establish a minimum bid. In foreclosures, it's mandated that it's a 2/3 minimum appraisal bid. You could have a higher minimum bid in a receivership auction, a lower minimum bid, or no minimum bid at all. So it's much more flexible. The last section on this slide talks about some of the things the courts can do when you do have a written contract. The court can say, well, I like that deal, but why don't you see if you could do better? And the court could say, go and see if there's some other deals out there in order to maximize the return to the receivership estate. If any of you have been involved in bankruptcy proceedings where there's what's called a stalking horse, that's what this is similar to, just to make sure that the property gets the best price possible. And it also says that if you do have a stalking horse situation, if there's an unsuccessful original purchaser that was involved to help generate maximum value, that original purchaser who didn't get the property can be paid his reasonable costs and expenses to the extent he contributed value to the receivership estate. Even though there's a lot of words in this statute, it's a pretty simple process for selling the property. You file an application. When I act as counsel for a receiver, we have a deal. We say, court, this is the deal we want to do. Here's the purchase agreement, or here's the auction procedure that we want to employ. Please bless this. Once that application to sell the property free and clear of liens is filed, you have to give at least 10 days prior notice, not a long period of time, to owners, parties, and all persons with a recorded or filed lien encumbering the property. Similar to who you would give notice to in a foreclosure proceeding of anybody who shows up on a preliminary judicial report. Then all of those interested parties have an opportunity to be heard. And if no one objects to the sale, the court can issue an order of sale without a hearing. If there is some objections, the court will hold a hearing and make a decision. Once that notice is provided, and if necessary, a hearing is held, the court issues an order that either blesses the required or the proposed procedure in the case of an auction, or blesses the proposed purchase and sale agreement that the receiver wishes to consummate. That's it. If the court blesses in the case of a written agreement, if the court issues that order of sale, that's the final appealable order. You don't have to wait for confirmation like you have to in a foreclosure sale. And really the property can proceed from that point on. What happens when that sale is consummated? The liens transfer to the sale proceeds in the receiver's hands in the same order of priority. I had a case in Scioto County where there was a huge lien dispute because there was some fraud involved where mortgages weren't recorded and refinancing proceeds were absconded. We had a huge fight over proceeds, and in a foreclosure, it would have lasted years. We had a receivership appointed. The property was sold at a much higher price than it would have had it gone to foreclosure. And although we still had the lien priority dispute, we fought over with the proceeds sitting in court and the property sold at maximized value. Once the court blesses that, it's now statutorily that those liens are off that property. What used to happen, I know there's some title insurance companies here that because this really wasn't statutorily mandated or prescribed and there was just some case law, that title insurance was hesitant to issue title insurance in a case where a receivership sale was issued free and clear of liens, especially when there was any objection, because it wasn't clear that this was a statutorily authorized process for clearing title to a property. It is now, and I believe that the title insurance problems that some people had with these types of transactions have, for the most part, fallen by the wayside. I see Bruce shaking his head, so I think that's an issue of the past, and that's one of the main benefits of this statute, is that you don't have concerns over insurability of title, given this statute that now says a receiver can sell property free and clear of liens. There is redemption rights like there is in foreclosure, but they're much shorter. They could be as little as 3 days. So where in a foreclosure sale where, first of all, you don't know what you're buying because you really don't have inspection or due diligence rights, and you're always worried that someone's going to come in and redeem, that it kind of chills the interest in the property and getting qualified and maximized purchase value. With this short redemption period, buyers or prospective purchasers in a receivership sale are going to feel more certain that they're going to get the property and they're going to get it more quickly without the time lags and the fear of redemption that exists in foreclosure proceedings. The new statute says that if you want to redeem, and again, this period could be as short as 3 days, the owner, in order to redeem, has to pay the greater of the purchase price or the value of all of the liens on the property, including all principal, interest, costs, and other amounts secured by the liens. Like I said about confirmation of sale, if it's a written contract, you don't need that confirmation any order anymore. Once the court approves the sale, the receiver just has to consummate the sale and basically execute and deliver a receiver's deed to the property and file a certificate and report of sale, basically said, I did what the court approved. If it's an auction or something where the sale order specifies a procedure as opposed to blesses a written contract, you still do have to get the confirmation, and then the court will say that, yes, the court-ordered auction process was followed and the sale was consummated in accordance with the procedures that the court approved. But for most cases where you actually have a deal in place, once that sale order goes on, there's no confirmation order needed, like there is in a foreclosure, or actually in bankruptcy sales. So what are the benefits of all of these changes to the statute? Well, it's easier to get receivers appointed. Like I said, if you have a default and you have loan documents that say you can get a receiver appointed, it's done. For income-producing properties, you can get a receiver appointed where there's an assignment of leases and rents so that the income goes down to pay the loan. Again, there's deference to the applicant's receiver recommendation, and we'll have to see how that plays out, whether this priority consideration means the court actually appoints who the applicant wants, or he's just going to think about it, the court's going to think about it for a second, and then appoint whoever donates to his or her campaign the most. We'll have to see how that plays out. It allows for more orderly sales, which is going to maximize value because you could have inspections, you could have contingencies, you could have other due diligence activities as part of the sale process. You're not going to have the situation with the title insurance and the objections where it's going to be unclear as to whether a good title, free and clear of all liens, can actually be accomplished by this procedure because it is now statutorily prescribed. And again, with the shorter redemption period, there's going to be more likelihood that the purchaser in the receivership process gets the property and gets it more quickly. I know I went through a lot very quickly there, I hope it was understandable. If anyone has any questions now, we can take them. Otherwise, we'll just turn over the proceedings to Mark and go on. Yes?
One of the things that is new that you mentioned was the court may require evidence of value. And that used to be a pillar upon which underwriting we would look at. And I think even though the court, it's may, I think it's a good practice for the pleadings and the motion and the order that you should state some value, and that the value of the property actually exceeds the debt, or less than the debt that you're foreclosing on. This is a safeguard for due process purposes.
I think it's a good point because, again, this whole receivership, a receiver has an obligation to maximize the value to the receivership. There is some judicial oversight and scrutiny here, so in order to make sure that all the I's are dotted and T's crossed, it's a good idea. And again, this says may. I think I would suspect that most courts would, in order to cover their you-know-what, would want to make sure that there's some evidence of value so they're not approving a sale that really isn't in the best interest of the estate. Yes?
If you sell a property, the receiver sells a property free and clear of all the liens, are the lien holders just out of luck?
No, what happens is, for example, the one I was involved in Scioto County, it was a $150,000 purchase price. The liens attached to the sale proceeds in the order of their priority. So if the first lien holder had a $100,000 mortgage actually the only lien that doesn't transfer are liens for real estate taxes. Those stay put. The treasurer gets paid first, always. But after that, the proceeds will satisfy the liens in order of priority. So they're not out of luck. It allows the property to transfer free and clear of encumbrances, and then all the liens are transferred to the sale proceeds. That's right in the statute. Well, I thank you for your attention. Sorry, did someone else have a question?
Get paid off, or do they still remain on the buyer?
Well, the security will be discharged. The liability would still exist. It would just be an unsecured liability, unless there's a personal guarantee or whatever, if there's other security. It's just the security that's transferred over to the proceeds. Thank you, everybody.
Morning, everybody. Thank you, Rob and Ron and Meyers Roman. I appreciate it. My name is Mark Abood. I'm with Hanna Commercial Real Estate. I'm an attorney licensed in Ohio and in Pennsylvania. I'm a real estate salesperson licensed in Ohio and Connecticut. Don't ask me why, but we could talk about that later. Little bit of I'm not an auctioneer. I do oftentimes discuss auction law and auction strategy, so please, anything is fair game. Ask questions, interrupt me, take phone calls. Anybody who's heard me speak, we're all here to make money, and I don't want to stop you from doing that, so don't hesitate. Types of auction. Well, first of all, has anybody attended an auction of any type? Tell me, real estate. I would imagine. I may walk around a little. I'm going to drive the cameraman crazy here. But real quickly, type of auction: real estate, or has it been art? Examples? Real estate. Real estate. Did you represent a party, or were you just observing?
Represented a lender.
Lender? So did you credit bid, or were you buying? Or?
I was just observing. There was someone else doing that activity.
Okay. Live auction?
It was live.
Was there any other elements to it? Okay. So was it a court sale then?
It was.
Good. Okay. What other type? Who else? Yeah. Jack.
I've been to bankruptcy court auction, sold the general unsecured assets of a company, and I've been to a lot of your auctions.
And others, I hope. Fun to attend. So that's a theme. Fun to attend. Why is it fun? Active. I mean, you've seen some of the bidders. Okay. Passionate. Who else? Yep.
Receivership option.
Oh. Conducted. So you were the receiver, and you were appointed then by the court to actually market and conduct the sale of was it real estate and other assets? Yep. So that's a great comment that we may get into a little bit later as well. Ohio Ohio permits under 2329-151 not only well, receivers are always permitted to conduct sales, but not only that, but a private company can market and stand in the shoe, market and conduct a sheriff's sale or stand in the shoe. Federal court? Okay. So Ohio law permits private companies to, I'm not going to do any, you could, or we could just, I don't have any PowerPoint. A private company can be appointed by the court in Ohio to market and conduct a sheriff's sale. So that allows for a lot of creative strategies when it comes to the disposition of assets. It gives a lot more flexibility, doesn't tie the asset to the court schedule. It allows it to maybe move quicker and more efficiently. Who else? Anybody else have any thoughts on auction? Yep, you attended?
Yeah, it was
Art. And so it was a residence.
No, it wasn't
Or-
a residence, I worked for an auction house,
Okay, contents.
yes.
People show up at the property?
No,
Was-
they had a site that they would.
Oh, okay,
hold auctions at.
very good. And so that's another live environment, it sounds like?
Yes.
Do you ever take bidding then online or
It was over the phone bidding.
over the phone bidding? Can be just as passionate, I'm sure, huh?
It's a little strange, I guess, with the over the phone bidders. It's just, you can't see them, you don't know what you don't get a body language from.
Body language critical. I think there are some auctioneers in the house as well, and I know my partner Mike can tell you a lot about how much you can tell from someone's body language and from actually physically seeing and reading the bidders in the audience, how important of a component that is.
That's why live auctions are so great, because of the transparency, bidders can see the other bidders bidding against them.
Yep. To Mike's comment, transparency, how important it is from a bidder standpoint to know that who you're bidding against is actually a bidder and someone who has met the qualifications to bid by bringing certified check or signing the purchase agreement or actually walking out with the art or personal property as well. Important to the sellers to know that the bidders that are there physically are people who can and have met the requirements to close. So transparency is a significant component of an auction or a successful auction strategy, at least in my opinion. Yep.
I've been to two auctions. One was an Amish auction. This is interesting. Produce, livestock,
Horses and...
horses.
Oh, really?
Yeah.
I haven't been to one.
Of course, I've been to our auctions. And then I was involved in an auctions.com auction, which I was shocked at the lack of transparency. Actually, I found out there's only one bidder, and he had put an offer previously, and they said, we're going to hold off till it goes to auction.com, but they gave the illusion that there were all these people bidding. It's kind of like eBay, except a little less transparent.
So what Bill is mentioning is that there's other types of auction strategy, not necessarily being a live auction environment, but there are other ways to sell property and sell assets. Your experience wasn't as good with the eBay style, auction.com style of auction, although it is a strategy, and as we know, a strategy that a lot of people do utilize over the years. Ohio recognizes two types of auction format or auction process. Ohio auction is governed under 4707 of the Ohio Revised Code. On one end of the spectrum, you have what's called a reserve auction. And a reserve auction is an auction in which the seller has the right, the absolute right to accept or reject the high bid price regardless of what it is. So you as a buyer could be the high bidder at the auction but not know whether you got the asset or not because it is subject to the seller's acceptance after the auction. So many times you'll have a bid situation where there's a high bid, and then 2 or 3 days later the seller may come and decide that they want to counter that high bid. Quite frankly, it is the path of least resistance for a seller. It's easy for a seller to say, yeah, I'll do that. But quite frankly, in our experience, and in I think many of you who have been exposed to auctions will share with you, it doesn't generate the momentum, it doesn't generate the bid call, it doesn't generate the fever or the passion, and quite frankly, it doesn't generate the interest. Prior to being with Hanna Commercial, I worked for a developer, and we would not attend an auction that was a pure reserve auction. We had a bad experience with it. We were the high bidder, and we got countered, and why were we there? There was a room full of people. We were the market. We were the top of the market, and the seller was asking us to come in at a different number. We told them to pound salt. We ended up getting it for a lot less than our offer that we made at the auction down the road. But we vowed we wouldn't participate in all of the headache and the due diligence and the homework that needs to get done if we didn't know that we were going to get it if we were the high bidder. So on the other end of the spectrum, you have does anybody know what the other end of the spectrum is, just out of curiosity? Absolute auction. Absolute auction means what? It's gone, baby, that day. Is that you, Andy? Yes. Hey, how you doing? Good to see you. Absolute auction. It's gone. You hear it, it's the saying, a dime or a dollar. No matter what happens, that asset is going to be sold that day. A lot of risk for a seller, right? There's a lot of uncertainty, a lot of unknowns, maybe not, a lot of perceived unknowns. But we will argue, and I will argue with anybody, that it generates the highest price every time, no matter what the situation, if the asset's been properly marketed. So if the asset's been properly exposed to all possible buyers, nobody likes a bargain better than the consumer or the buyer. So everybody will be, the reaction you get from the marketplace is, I got to stop what I'm doing, I got to come out and take a look at this asset. Because if I'm the only bidder there, I might get it for a dime or a dollar. The problem with that is, from a buyer standpoint, is if you're thinking that as a buyer, who else is thinking that? Everybody. So when you have everybody, you've now uncovered the entire marketplace. It is the equivalent of, the asset will sell if properly marketed for market value. Why? Because you've uncovered the entire pool of potential bidders. Probably some people who didn't know they were bidders will also stop what they're doing and come look at it just because of the appearance of a bargain or the perception that they may get it at a bargain. And so as a seller, you can be assured that everybody will come and do their due diligence and appear at the auction with their check in hand because they may get a bargain. It also forces that highest bidder, the person that you don't know in the market, to go higher and higher and higher. It forces them, because you've captured all the opinions of value, you've captured all of the market interest, those low bidders as well as the mid-level bidders, and whoever might be out in that audience, the high bidder, it forces them to go as high as they could possibly go and usually higher. What are any questions on that? Absolute. In between, it's not recognized statutorily, but it's recognized in the auction world. There's a mix somewhere in between. It's called a published reserve auction. Published reserve is where the seller states the price at which the asset becomes an absolute sale. It is a minimum bid at which the property will be sold if bidding reaches or exceeds that figure. And that's a great alternative for folks when there's maybe some mortgage or some liens on the property, or if there's partnership interests where they need to come to a situation where they can only market the property at a certain price. That price that's set, in our experience, typically has to be a price that is set so low that it achieves the same psychological result as an absolute sale. So if there's an asset out there, and we're not talking just it's not the price at which the seller would be agreeable to sell if they had to on their worst day. It's the price at which the seller would be sick if they had to sell it at that price. And arguably, we talk about this all the time, arguably a buyer will take 10 of them all day long if they could get it at that price. So it has to have that same effect of, I got to stop what I'm doing, because if I'm the only bidder at that auction at that price, I want to be able to get that asset, and I'll take as many as you got. So it does provide somewhat of a floor, somewhat of I don't want to call it a comfort level, because it's usually an uncomfortable number. But it's a number that still achieves we want to still capture all those bidders. It's widely used, and many times it's used in commercial sales. What are some reasons for a sale? Anybody have any ideas of what are some logical, where you don't look at asset type, you look at asset situation. So what are some situations that might warrant an auction sale? You mentioned it, court sales, 363, bankruptcy, receivership, foreclosure, separation, breakup, divorce, right? All those are court type sales. What other type? Estate planning, liquidation, conversion of an asset to cash so that the partners can go to Florida and retire. Right? What else? Overstock. Sure. Yep. What else?
But anytime a seller becomes more time sensitive than price sensitive, and that could be many.
I love hearing you. I love hearing you talk. You could give this better than I can, certainly. So time sensitivity, where someone is more sensitive to the time. They need to have it sold for whatever reason by a date certain, rather than by getting a certain price. So there are many occasions, and I think we see that in all categories of assets and in all situations, where someone they just want it gone. They bought another property. They need the cash to put into another property. They have an opportunity elsewhere to make an investment, and they want that capital right away so that they can deploy it then right away. What else? Yep.
We disposed one with you that the lender, the borrower was in default. The property was underwater, and I was surprised the lender agreed to the auction to settle it for some minimum bid.
You come up with a great point, that there was a lender workout that actually involved a lender having a very significant involvement in the disposition or the way it was disposed. We talk a little bit about auction strategy, and I'll summarize auction strategy by saying simply that there is no limit to the type of strategy that can be employed in an auction environment. So I think people often just categorize an auction as a very simple process that everybody comes in a room and you don't know what exactly is going to happen. All you know is that the high bidder is going to get the asset. There are, and we as professionals and lawyers and real estate professionals create new strategies all the time. From our standpoint, I love hearing more about the situation so that we can craft a program that achieves the result of our seller client or lender client or receiver client, that isn't just quite a simple sale. We're having a situation now where we're now going into the third round of an auction over a period of, how long, Mike? A year and a half, 2 years? It's a multi-round sale because there's so many lawyers, so many secured creditors, bond assessments, tax liens on the property, that it has to go through a very creative process to peel away each of the complexities of the sale. And so as long as there is a situation presented, there is a strategy that can be employed. There is no one vanilla, auction box. What are some of the advantages, other than, I know we talked about time sensitivity. What do you think some of the advantages might be to get it sold? Getting an assets, go ahead. Yeah.
Well, it's a nice clean deal because you're selling it with no contingencies. The assets were with a pretty quick closing. It's all sellers love that.
So you're talking about most sales are quick closing, 30, 45 days, non-contingent, big earnest money deposits put down. Yep. We control the contract. Our seller client, our client controls the contract. Yep.
Mark, when I was talking about the receiverships and that there is now a statutorily prescribed way to clear the liens. How do you deal with that issue in an auction where there isn't any statutorily prescribed mechanism or other thing where the liens disappear when the property's sold? So someone's going to buy a property that may be significantly or fully encumbered.
I love it when there's no statutorily prescribed solution because that gives us what? It gives us deference and flexibility to create our own strategy. But what do you do? I think the new law is great to that point. It allows the receiver the flexibility to create a strategy that disposes of the physical real estate asset, converts those assets to cash assets that then fall under the court's supervision for distribution among creditors. So you are able, and I think it's no different than selling the asset itself and paying lien holders. What it does is it really accelerates the process, and it really takes the handcuffs off of the receiver, the lenders, and then many times it helps out the borrower too, because it creates a competitive environment for an asset that may not have had a competitive environment in its universe ever.
So are most of the auctions that you do actually conducted within a receivership setting?
I wouldn't say most of them get done in a receivership setting. I think we've had auctions that have had strategy within court setting, within 363 sales setting, within receiver. We've been appointed simply to market a foreclosure sale where we weren't the agent selling it, and we weren't the receiver, and we weren't an agent to the receiver because there wasn't any. We've been involved where the lender simply hired us to market the sheriff's sale date and to have private open houses because the court allowed us to do so. So there's, again, it goes to the point of as creative as the strategy as you can think of, it can be accomplished. We have many private sellers. That's just their chosen methodology of selling an asset. They don't want to deal with real estate brokers on the buyer side. They don't want to deal with lawyers on tearing up their contract, and they don't want to deal with the buyers retrading the deal and having long due diligence periods. They just want the asset sold, and whatever they don't want to set a price out to the marketplace. They want to let the market sell price. So as many strategies as you could think of. We have many private sellers. We work a lot with the other agents. We work with other real estate agents who maybe have a stale asset. They've been listing it for a couple years and they want it. Their client finally wants it to move. I know we have more to talk about in different types of sales, but yeah, go ahead, Steve.
So you just hit on it. So, property owner X has a property. He's got patient. Time is not an issue. He approaches you. You wear different hats. You got the auction side, you got the sales side, and he wants to use you or company X, one of the others around Cleveland here. How do you pitch the person to say, we want to represent you, and the auction side is the way to go, or the sales side is the way to go?
It takes a lot of listening as to what their goal is. We talked about situation. First question is always, what's the situation? Why are you here? Second question is going to be, tell me more about the asset itself. Tell me what kind of action. Has it been marketed in the past? Has it not been marketed in the past? What are your goals? What do you want to see happen at the end of the day? And what are the impediments to being sold? What have been the hiccups in the past? So a lot of that's how we oftentimes will get to the point of, boy, you might consider an auction as a viable alternative to get this asset sold for the highest possible price. It may not be the option to sit on the market for a period of time. We can do it because in our, as Hanna commercial, we can do it, but so can this one, and this one. You want to go to an auction strategy, we believe we have a creative methodology and a successful platform to get that asset sold for the highest possible price. And a big component we always talk about is passing the brokerage fee on to the buyer. Huge advantage. In a regular real estate transaction, asset is sold, brokerage commission comes out of the purchase price, and so if it's $1 million, you're not getting $1 million, you're getting $980,000 or $930,000. If an asset is sold at auction at $1 million, you're getting a 10% buyer's premium added to that, so the high bid price is typically something more than the purchase price, or more than the high bid price. So, yeah, go ahead.
One thing that I found interesting, this is to do more with residential properties, but actually lately I had two of my clients that sold their house through auction because the property was worth a lot, the properties were worth a lot, but they were older. And the thing that attracted them was the ability not to have to deal with contingencies.
It's the biggest thing. Houses are a great auction candidate. Why? Because everybody's emotional about houses. I mean, my wife, I've done now with my partners hundreds of auctions over the last 9 or 10 years, and many before that in my other capacities. My wife wanted to go to a house auction, and I was scared to death to go to this house auction with her because I knew she was going there to buy. And thankfully, my partner went with her and kept her hand down past a certain point, and then that's why I'm still able to pay the bills these days. But thank you again for the questions. Thank you for the opportunity, and thank you, Rob and Ron, as well. Pass it on.
But I'm talking about note sales and sealed bid sales, and I'm going to start talking about note sales. So what is a note sale? Instead of buying the real estate, the seller or buyer is selling and buying the note and the mortgage securing that note, which encumbers the real estate. So it's buying the loan, it's not buying the real estate itself, but it may ultimately want to get the real estate that way. So from the seller perspective, what are the advantages of buying a note versus buying or selling a note versus selling real estate? So it enables the seller to cut its losses and to move on. Doesn't have to go through the foreclosure process. It's getting paid for the note and it moves on. No more battles with the borrower, no more back and forth. And typically there are relatively few representations in a note sale purchase agreement, and the sale can happen relatively quickly. Big disadvantage, obviously, is the loss of principal, because nobody's going to buy the note for face value. They're going to buy it at a substantial discount. From the buyer's side, the buyer of a note wears two hats. It's both a lender, has to look at the transaction both as a lender and as a real estate investor, because it may very well end up owning the real estate, and that, again, may be the plan. So the due diligence that the buyer's going to do involves both lender concerns and investor concerns. So the lender concerns. The buyer of the note is going to, as a lender, as a future lender, is going to want to know what are the lender's rights and obligations under the loan documents. Are there any obligations to make future advances? Is this a construction loan, or does it have a construction component to it where the buyer of the note may have to advance some more money to the borrower? Obviously, it's going to want to know what are the default provisions in the loan documents. What are the borrower notice and cure rights? What are the lender's remedies in the event of a default? It's obviously going to want to know what is the priority of the loan. Is it a first position mortgage or something else? What are the guarantees? Who are the guarantors? Is it a non-recourse loan, or is there some recourse against the borrower? It's going to want to know what is the current status of the loan. Is the borrower currently in default? Has it been in default in the past? What is the payment history of the borrower under this loan? It's going to want to know the financial condition, obviously, of the borrower and the guarantors, and the condition of the loan documents. Is everything in place? Are all the T's crossed and the I's dotted? And it's going to want to look at the prior correspondence with the borrower so it knows kind of what the history is. And most importantly, it's going to want to have, the buyer's going to want to have a plan. What's it going to do after it acquires the note? Is it going to do a modification of that loan with the borrower? And we'll see that could have some tax consequences. Is it going to do a deed in lieu of foreclosure? Or is it going to go to foreclosure or do a receiver sale, as we've talked about previously? So you got to have a plan. From the investor standpoint, it's like any real estate deal. Obviously, you want to know what the condition of title is. You want to know that there are no environmental issues. You want to know who's managing the property, that they know what they're doing, and that they'll be able to do it properly. And you're going to want to know what is the status of the leases. Is there vacancy? When are terms expiring? What was the rent? What is the credit of the tenant? All the typical real estate investor concerns. You're going to have those concerns when you're buying a note. So you get through the due diligence, you decide you're going to go ahead, you get to the note purchase agreement. Typically, there are fewer representations and warranties in a note purchase agreement than there would be in a purchase agreement for real estate. They're probably going to be limited to the status of the loan, that the seller owns the note and the loan documents, has the right to sell them. There's not going to be anything about the condition of the real estate. There may not, the due diligence period is probably not going to be that long. Oftentimes the due diligence will be done in advance of the actual signing of the purchase agreement. The purchase agreement should identify all the loan documents that are part of the transaction, and it should require the seller to deliver all communication that it's had with the borrower, so the buyer knows what's going on. Yeah?
Is the potential buyer allowed to have direct conversations with the borrower prior to?
I think a lot of lenders are reluctant to do that. I think it kind of depends. I see one or two bankers here in the audience, and I don't know what my experience is. They don't like to do that. I will say that I had a deal where I was representing a owner of a hotel, and we were doing a deed in lieu of foreclosure transaction, and there was an ultimate buyer that was coming in right away to get the property, and at the last stages of the deal, we started having direct conversations with the buyer in the deed in lieu. But I would say normally with a commercial lender, it probably is not something that they want the lender to do. Okay, so the big advantage, obviously, of a note purchase from the buyer's side is they buy the note at a discount, which presumably is going to be a substantial discount from the value or what the buyer sees as the potential value of the real estate. But there are tax consequences, and I need to preface this by saying I'm a real estate lawyer. I am not a tax lawyer. So, as I say, I know enough to be dangerous, maybe not even enough to be dangerous, but I did vet these scenarios with my tax partner. So I think it's important to know about this. These don't apply to banks buying the real estate, but they would apply to just a regular investor. So I want to go through these three scenarios. So the first scenario assumes that the note is not publicly traded debt and that the current lender did not buy the note at a discount, so it's the original lender. If the buyer plans to do a modification, which involves a significant modification, I'll talk about what that is, the buyer should be aware that it will have to recognize gain equal to the difference between the original loan amount and the amount the buyer paid for the loan. So, for example, buyer pays $3 million for a loan with a face amount of $5,000. If the buyer then significantly modifies that loan with the lender, it's going to have to recognize gain of $2 million on that when they do that modification. And the reason for that is it's deemed that the old note is replaced for a new note. So that's obviously something, if you're planning on doing a modification, you need to be aware of that. So what's a significant modification? There are 6 tests for that, but essentially, as you'll see, any modification that you're likely to do would be considered a significant modification. If you change the yield, if you change the rate on the note, if you change the timing of payments, you give the borrower an extension of the maturity date, or you say change it to interest only as opposed to principal and interest. If you change the obligor, you add a guarantor, or the security you add, provide for additional security, all of those would be deemed a significant modification. So scenario 2, buyer buys a note and then credit bids at the foreclosure sale. The buyer's going to pay tax on the difference between what the buyer paid and the credit bid. So if the buyer, let's say, bought a $5 million note for $1 million and then goes to foreclosure and credit bids at $3 million, it's going to pay tax on the $2 million gain between the 1 and the 3 that it bid at the sale. And then scenario 3, buyer buys a so-called performing loan with more than 12 months remaining on the term. The buyer must recognize the original issue discount over the balance of the term. So example, buyer buys a $5 million loan for $4 million with 5 years remaining in the term. Any principal payments up to $200,000 per year in that example would be considered interest and taxable and not non-taxable principal, which you would normally expect. So as far as what a performing loan is, all it means is the buyer's paying current at the time, the borrower's paying current at the time the buyer buys the loan. It could have had all kinds of payment problems before, but if it's paying current at the time of the purchase, it's considered a performing loan. So you get through all of that, and then the closing of the note purchase, just a few things that you will need. You want to make sure you get the original promissory note and that you have it endorsed to you, which would either be on the note itself or on an allonge, which is a separate piece of paper that basically says pay to the order of the buyer. You want to make sure that the mortgage and other loan documents are assigned. You want to get notice letters from the seller to the borrower and to the borrower's insurance agent notifying the borrower and the agent of the transfer. And of course, you want to get an endorsement to the lender's title policy, naming the buyer as the new mortgagee on that policy. So that's note sales. I want to then talk about the sealed bid sale. So what is a sealed bid sale? Basically, the seller provides a purchase agreement to all the potential buyers. It includes what the required earnest money is, all the terms of sale, leaves a blank for the purchase price, and the buyers are just asked to fill in the blanks and submit the purchase agreement. So I want to just tell a war story of my first experience with a sealed bid situation. We were representing an owner of a downtown office building, and we were negotiating with a prospective purchaser who was planning a major renovation and conversion of this building to residential. And I don't remember the exact numbers, but my recollection is we were talking in the neighborhood of $9 million for this building. And we were somewhat into negotiations. We hadn't signed a purchase agreement, obviously. I don't even remember if, maybe we were in the original stages of negotiating it. And another buyer surfaced that was very interested, I think was coming off at 1031 and needed to invest the proceeds. And we decided to go to a sealed bid situation. I prepared a purchase agreement, said these are the terms, you fill in the dollar amount. And the buyer that was originally going to pay $9 million for the building came in with a bid of $12 million. And I remember opening the purchase agreements, my hands were shaking, and so it was quite a good thing for the seller, obviously, and the other buyer, I think, bid maybe in the high tens. So this buyer went from $9 million to $12 million. So what are the advantages of a sealed bid situation? Seller controls the purchase agreement. It sets forth all the terms, just like in the auction situation, but it's the same situation. All the terms are set forth in the agreement. Seller controls the process. It sets forth, again, the terms. as one of my colleagues, I'm quoting you, Bruce, here, all cash, non-contingent. The deal, you can do that with a sealed bid, and you get a quick close with no due diligence, very much like an auction situation. The disadvantage, although it wasn't in the case of the deal that I worked on, but oftentimes there are substantial upfront due diligence costs, which the seller is typically going to have to pick up. You may be able to get the buyer to pay for some of those costs in the purchase agreement, though. So when would you use a sealed bid versus an auction? And Mark, I'm not sure, you may have different thoughts about this, but this was, I talked with a longtime client and who does a lot of this, and so this was his analysis. He said, if there's a small number of prospective buyers, generally you would use a sealed bid, and if there's a perceived wide range of value, you use a sealed bid. So if somehow you perceive that there are a few buyers, two of them think the property's worth $500,000 and one thinks it's worth $1 million, you're better using a sealed bid, because if you went to an auction, you know, the guy that thinks it's worth $1 million may get it for $550,000. Now, I don't know, there's definitely an art to knowing who thinks the property's worth what, but if you do that, it would seem to me that that's the sealed bid is better. If there's a tighter range of values and lots of potential buyers, then the auction format is probably better. Do you have any thoughts on that, Mark?
Yeah, I mean, I think there's definitely forms and environments to be able to use a sealed bid if it's done, again, properly and properly marketed. I don't think that it forces the buyer to come up with their best number, whereas an auction always forces the buyer to come up with and oftentimes exceed their best number or the number they were willing to pay. From a sealed bid environment, it doesn't there's no incentive for the buyer to really lay it all out there, because in at least many of our experiences, the sealed bid sometimes gets countered. So while you submit the sealed bid, many times you get a callback that says, hey, you're close, do you care to revise your, sealed bid? And many times the buyer does. But I think it has its place, and I know people have a comfort level in using it sometimes.
Mm-hmm.
I don't know if Mike, if you have any, Mike's if there's any other perspective on that.
No, I agree with what we were saying. There's but no. There's a time and a place for a sealed bid. Actually, the problem with sealed bids, in my opinion, is the lack of transparency. Yeah. And you're right. In many cases, it doesn't force them to stretch as far as they'll stretch. You got very lucky.
Yeah.
It was skill, I'm sure, right?
Yeah.
It's better to be lucky than good.
I've been involved in that for the last 10 years, and that doesn't happen a lot.
Yeah.
So you got very lucky.
So sealed means just that, lack of transparency
Yeah,
for those that
that's
didn't
true.
hear it.
All right. Are there any other questions? Yes.
I wonder if between the combined presenters, if there could be a discussion in the market. Like a lot of what we've talked about today is how to handle an unfortunate situation for the seller. But do you see things coming along in the market that says that's really what to talk about right now? What's the market then, or at this point today, what do you see happening in the future?
Well, I can tell you as a real estate lawyer, this is the most active year that I've seen since 2007. I still think it's not back to the good old days, but it's certainly a lot better than I've seen it in a long time. What's your thought on that?
I think there's a lot more activity. I think deals seem to be, this is my personal opinion, I think deals seem to be taking longer still to happen and to close. I think there's a lot of times, whether it's in the traditional market environment or in an auction environment, I think there's a lot of activity going on right now, certainly with all the robust discussions and development going on in downtown Cleveland and the surrounding area. There's a lot to talk about and a lot to be excited about. But one of my colleagues mentioned in a meeting yesterday when we had a company meeting, you know, a lot of those loans that were done in '08, '09 to withstay, you know, to stay some of the stress or trauma that was occurring on those assets, a lot of those loans are now kind of coming up for discussion. And so at least personally, I've now fielded a lot of new calls on, you know, hey, will you go take a look at this because we may have a need for a receiver, we may need to look at a, you know, program to get this off of our books, or we may need you to talk to the borrower to get it sold because we want our, you know, we want out. So that's been my experience at least. So it's been very unusual, both ways, very positive, but also some fresh discussion on distress.
Yeah, I think the market's somewhat fragmented from my perspective. You see some of the new and exciting developments are going on, but then you see some of the older properties that are distressed. I mean, I can name off the top of my head several older properties that are in receiverships in Northeast Ohio that aren't riding this wave of resurgence that we see downtown and elsewhere.
Are you seeing value, in your opinion, are you seeing values going up, or are you just seeing a lot of transactional activity increase?
I think, again, it kind of depends. I think in the top of the market, there's a lot of value. In some of these distressed properties, and again, I'm a litigator, so I see the distress more than the good stuff. But
you're still here.
Yes, and so I think where you have older properties that aren't candidates for these conversions to residential, or older shopping centers, that there is distress out there, and think of all the retail and shopping centers that are in receivership. Severance, University Square. I mean, those properties aren't, Chapel Hill, those aren't riding the wave of being in the best time since 2007 that some of these other projects are, like down in the Flats and all the things, Nucleus and all the things you see going on downtown.
When an investor, let's say, goes into either a note sale or a sealed bid versus the auction, and they do a modification, and let's say that perhaps the original loan had some tax advantages because he had some tax abatements, will those still continue if a modification is done to the original note?
Well, the tax abatement would go to the owner of the real estate. So, you know, I can't, so I don't think, it wouldn't affect the modification itself, I don't think would have any effect on the tax abatement. Are you talking about if there was a modification and then the note buyer ultimately owned the real estate?
Correct.
I think that would depend on what the terms of the tax abatement were, and so. Yes?
Thinking about buy-sell activity, what impact is the GOP convention having on the market? Is it strictly local? Is it spread out? Is it nothing?
You know, just as an observer, I mean, I personally think there are an awful lot of hotels being built, and I don't know, you know, maybe they'll be very full for the convention, but I'm a little concerned about what's going to happen after the convention. You know, I don't know how much of that is driven by the convention, but anybody have any thoughts on that?
We just heard a presentation from John Penny, who's at Corman Jackson, I think, who's on the RNC committee. And I think there's a lot, it's an unbelievable economic impact, for sure. We've also spoken with our residential partners in Howard Hanna, who has the exclusive contract to rent, you know, for whatever that means, the exclusive representation for temporary housing for the RNC, and so far that they haven't quite seen the houses get rented yet that everybody's talking about. But I think the perception is that will change when the candidate pool gets narrowed to maybe 4 or so. So from the residential standpoint, we'll see it. You know, from the hotels, that goes without saying. Every hotel room would between here and 30 miles from here will be booked solid. There's a lot of office rentals that are for short term, taking space downtown. Bill, you probably know more about that than I do, about some of the groups that are starting to make their wave into town, and maybe there's others that know a lot more than I do about that, but that's what we're hearing from the marketplace.
Anything else? Well, thank you very much for attending.
Thank you.
Thank you, everybody.